thank you all for coming. I know that there's a lot of competition for good panels during this time slot, so we appreciate your attendance. And we especially appreciate it because we've got 4 people who really know this topic and who are generously here with their time and their expertise. This is obviously Citizens United versus Federal Election Commission, the wake of it, and we've had action almost from that January 21st date that the court decided it. As we all know, it's been a defining decision for the Roberts Court this term and potentially for terms to come. And it immediately was put into play a few days later when President Obama, during his State of the Union speech, addressed it, saying that it reversed a century of law and opened the floodgates to special interests, including foreign corporations. It was that memorable moment when Justice Alito then mouthed, "Not true." And a few days later, about a month after that, Chief Justice John Roberts then responded with a salvo of his own, saying that anyone can criticize the court, but please remember the setting, and if we're going to come and listen to your State of the Union address, we don't really expect to be criticized. So it's gone on from there. The justices themselves have talked about it publicly and in private interviews, so I think this is this certainly has become an opinion that's, as I said, defined the court. It's also defining legislation in Washington, and we've had more developments even this week with the remedial legislation that our panelists will touch on also. Let me first just remind everyone to turn off their cell phones and to also let you know that we're going to go until half past the hour, and then there'll be 15 minutes of networking after this before the luncheon speech. And just to let you know how we're going to do it, I'll introduce our panelists first, and then just remind everyone a little bit about this decision that played out over, I think we had 176 pages over about 5 different opinions, and then we'll go into commentary from our panelists on what's happened since, the impact in elections, the predicted impact in the midterm elections, the legislation, and just how it's already played out, and the future for any kind of fixes. Let me introduce our panelists first. More thorough bios of the 4 panelists are in your materials there, but just so you know, in alphabetical order, we have Mark Elias, who's at Perkins Coie as the chairman of the Political Law Group. He specializes in representing public elected officials, candidates, and parties, and has represented the Democratic Senatorial Campaign Committee and numerous other individual senators and representatives, governors, in their campaigns. Ben Ginsberg, from the other side of the aisle here, is partner at Patton Boggs, where he represents political parties, but of the other stripe, members of the other stripe. In both the 2000 and 2004 election cycles, he served as the national counsel to the Bush-Cheney presidential campaign. We have Mark Schneider, who is the counsel for political programs and associate general counsel at the Service Employees International Union, and he's formerly with the FEC and the Department of Justice. And immediately right here to my left is Margaret Yoon, who directs the Brennan Center's Campaign Finance Reform Project, involved in several cases, spin-off cases of this, and that's another thing we'll want to touch on in other litigation that has been spawned and affected by the Citizens United ruling. Just to remind everyone, probably anyone who's come here has read this opinion several times, but it certainly is worth reminding folks how it started and what the court ended up saying, since it obviously has been so provocative. In the majority, written with Justice Kennedy, obviously was the Chief Justice, this familiar 5 conservatives who've really reshaped the court in many ways: Chief Justice John Roberts, Justice Antonin Scalia, Clarence Thomas, Samuel Alito, and as I say, with Justice Kennedy writing the opinion, and Clarence Thomas also joining, said for the first time that there's a First Amendment right for corporations and labor unions to use their general treasury funds on indirect expenditures on behalf of candidates, directly reversing, of course, the 1990 Austin versus Michigan Chamber of Commerce decision and portions of the 2003 case of McConnell versus Federal Election Commission. As Justice Stevens said in his very poignant dissent, portions of which were read from the bench that day, really the only relevant thing that has changed since Austin and McConnell is the composition of this court. We'll talk a little bit about the individual justices, but mostly we're here to talk about how the ruling itself has changed the lay of the land. Justice Kennedy's rationale really went to the core of the First Amendment and talked about the suppression of speech, used words like censorship, and said when the government passes the kind of ban that was part of McCain-Feingold, the government prevents the voices of manifold corporations, both for-profit and nonprofit, from reaching the public and advising voters on which persons or entities are hostile to their interests. Kennedy pointed to the rapid changes in technology, including blogs and social networking, and he said the First Amendment does not allow Congress to distinguish between the context of political speech or the corporate identity of the speaker. And as many of you know, Justice Stevens and the dissenting justices came back and essentially said, get real. There is a difference between a corporate speaker and an individual speaker. And in their dissent, they forcefully rejected the notion that corporations aren't different from individuals. Justice Stevens was joined by Justices Stephen Breyer, Ruth Bader Ginsburg, and newest Justice Sonia Sotomayor. And, you know, what they said was that the approach to the First Amendment may well promote corporate power at the cost of individual and collective self-expression that the First Amendment was meant to serve. And there was a lot of predictive rhetoric in the dissent about what this might do to elections and to democracy from here on out. And that will be our jumping off point for starting with Monica Yoon and looking at the impact and how some of the rhetoric about the impact has been overblown also, but if you could give us a reality check on where we're at.
Sure. And I've spoken about this case a number of times in the intervening months, but I'm particularly happy to address this at ACS because I think that it really brings home to us the continuing relevance of what one might think are rather abstract and scholastic constitutional issues. Because we have lost a question of constitutional interpretation, we will lose elections, we will lose policy votes, we will lose ground on a lot of the things that we progressives have made part of our agenda and that we work toward all the time. So this is I'm very happy to see the size of the crowd here because for a long time, campaign finance was the realm of kind of good government nerds, and you would not have had this kind of turnout had this panel taken place last year. But in any case, in terms of what difference it makes and sort of bringing that home, prior to the decision, if Exxon Corporation wanted to engage in electoral campaign speech, it could start a PAC. And Exxon did start such a PAC in 2008. And it raised about $700,000 by saying, hey, of you guys, who wants to contribute to support the Exxon agenda in electoral politics? Now, as a result of this decision, Exxon's entire corporate profits for the period, $45 billion, are now open for use in Exxon's campaign war chest. This is a difference of about 50,000 times. Suddenly, the war chest that Exxon is carrying around in elections has increased by a factor that is exponential. And I mean, I'm not saying that Exxon has any plan, or any particular corporation has plans to devote the entirety or even, a significant fraction of its profits or of its war chest to direct intervention in elections. But that possibility is there, and that possibility must be reckoned with, especially given the relatively cheap nature of federal elections. People talk about the 2008 presidential election being the billion-dollar election in presidential terms, as if that would even cause a lot of major corporations to blink. The average congressional representative campaign costs about $1.3 million. The average Senate race costs around $5 to $7 million. We can expect that level to increase, but these these direct campaigns are dwarfed already by the amount that corporations spend in lobbying, in more indirect forms of advocacy, and now that they are able to bring their profits to bear directly in campaigns, the possibility that a corporation without much effort could put a thumb in the scale in swing districts is one that has to be reckoned with. And I also want to talk about what post-Citizens United political spending can be expected to look like. Because one of the problems with the Kennedy opinion is he assumed that that such spending is easy to track, that such spending is going to be based on the issues, that such spending is going to be something like, BP saying, vote for Joe Barton, we really like him, he's our guy. That's not what corporate intervention in elections has ever looked like, and that's not what we can expect it to look like after Citizens United. It's very hard to track the influence that Citizens United will have for the simple reason that a lot of this spending is not disclosed. It's not disclosed to corporate shareholders, it's not disclosed to corporate boards, and it's not disclosed when corporations use front groups or use trade associations as conduits to mask their political activity. But what we do know, we're beginning to get some sense of at least what interest groups are willing to tell us they're going to be spending in the upcoming elections. The Washington Post has reported that major interest groups have reported plans to spend about $400 million in the midterms. In 2009, the largest trade association and lobbying organization, the U.S. Chamber of Commerce, spent $144.5 million. Now, that level of money poured into congressional elections already exists, and the idea of that being exponentially increased will, in fact, be a game changer. Second, in addition to being secret, corporate involvement in electoral campaigns can often be latent. If you are carrying a weapon into a negotiation, there is no need often to use the weapon or even to brandish the weapon. You know the size of the war chest you're going up against. I think that we saw that very clearly this week in the Disclose Act, when the mere suggestion that the NRA might be getting involved in the midterm races was enough to cause a lot of members of Congress to lose face, to back down. We have a particularly poignant example of what corporate political spending of the kind envisioned in Citizens United looks like in a North Carolina case, Leak, where the record contains an instance of a farmers' lobbying group who wanted a legislator to change his vote and to support a farm subsidy bill that this group wanted. And so they went to a political consultant and they created a series of campaign attack ads. Of course, these ads had nothing whatsoever to do with the farm subsidy or any issue, or any direct issue. Instead, they were personal attacks. They were smears. And rather than airing those ads, this farmers' lobby took these ads to the legislator and met with him in private and screened these ads for him and said, this is what is going to be unleashed on the eve of your election if you do not change your vote, and the legislator changed his vote. Justice Kennedy says that independent expenditures cannot give rise to corruption, and I think that to push back against that assumption is one of the essential things that we have to do. And there are certain myths that have dominated. I think in the absence of information about corporate political spending, there are certain myths that have dominated the narrative that we've been hearing in the press. I mean, one of which is, Citizens United will actually end up benefiting progressives. Look, the labor unions are getting involved. They were involved in, Blanche Lincoln's race. They have all this money, and corporations have all of this money, and somehow it's going to balance out. This is ridiculous. The amount of money that unions or other progressive interests have in comparison to the resources of corporate interests is minuscule, and is not, to assume that corporate money is going to distribute itself evenly across the political spectrum so that normal citizens can assume that moneyed interests are going to serve as a proxy for their voice is, I think, vastly mistaken. The bulk of corporate money is going to ally itself on the side of anti-regulation. It's going to ally itself on the side of further concentration of wealth. And if elections are allowed to devolve so that they are only about money, that's the reality that we're going to have to deal with. There's another myth that that campaign finance reform laws really do nothing. That corporations could already lobby, they could already do everything short, but say vote for or against a candidate. And I think that has a grain of truth. Certainly, there have been deregulatory decisions before Citizens United, notably in 2007 when the same Roberts majority knocked a big loophole in laws regulating electioneering communications. But to say that these laws are not worth defending, that these laws do nothing to stem the flow of money into politics is, I think, a deep mistake. In the 2008 election, we saw both parties nominate candidates who were not the candidates backed by the big money interests in the parties. We saw both parties build grassroots fundraising networks in which suddenly in the aggregate donations of $100 or at a time would start to matter. And this what the media has called the small donor revolution can be traced directly to the McCain-Feingold laws, which prevented corporations and other interests from writing massive soft money checks to the political parties. There is no point in spending time and money to develop grassroots fundraising mechanisms to collect all of these small donations through a vast network if a corporation can simply write a seven-figure soft money check to the national parties. So the gains that we have made as progressives, but also as a democracy, I think have depended on a political environment in which that big money was not allowed to dominate. Citizens United is not the end of the story in the courts, nor was it the beginning of the story. As progressives, we have worked, we have organized, we have elected our candidates, and we are in the position of asking ourselves, well, why is it that we do not have the climate change bill we want? Why is it that we do not have the financial regulation we want? Why was the health care struggle so fraught? Why do we not have protections for workers that we want? And the answer to this, when we have elected our candidates, when Democrats have a majority of both houses of Congress, when millions of people came together to elect an insurgent candidate. And I think that the answer to that mystery is similar to the answer that, we saw in Watergate. If you want to know what's at the bottom of this, you follow the money. And the patterns, we are like people who are feeding quarters into a Coke machine, saying, well, we keep giving this thing our quarter. Why is it that we're not getting what we want out of it? And I think the answer to that is the system is broken and we need to fix it. The conservative interests who saw their vision of corporate, of First Amendment protection for corporate free speech, I think, realized that in order to win in the long term, they needed to make an investment of the rules. They needed to invest in the rules of the game in a really deep way. And the Citizens United decision can be seen as the result of a 30-year push by certain conservative interests. They have been, they've filed hundreds of lawsuits, but even beyond the lawsuits, they have built a movement. They have built an ideology. They have been pushing this agenda in the law schools. They have been pushing it in political messaging, in grassroots messaging, and they have been pushing it, obviously, in policy and in the courts. And what they have been pushing is a vision of the Constitution that would have been laughed out of court 30 years ago. The vision that is based on three metaphors. The metaphor that equates absolutely money with speech, the metaphor that equates absolutely corporations with people, and the metaphor that equates absolutely elections with marketplaces, marketplaces where whoever has the most money has the right to dominate discourse. And so it's essential that we push back on this both in the short and in the long term. In the short term, there is, as Joan mentioned, a raft of cases coming up the pipeline, many of which will, some of which will be decided this year. In the next few weeks, we should hear whether or not the Supreme Court is prepared to articulate a constitutional principle of anonymous speech that would prevent or that would certainly call into constitutional doubt laws requiring disclosure of campaign finance contributions, that would assert a privacy interest in the secrecy of your of one's intervention in political money. Also, in the next few weeks, we should hear whether or not the Supreme Court is going to move forward with the RNC versus FEC case. This is the case that challenges the other half of McCain-Feingold, the soft money ban. This was a case that was filed 10 or so days after John McCain stopped being the presidential candidate of the Republican Party, and the RNC political director was very explicit. He said, "We are filing this lawsuit because we cannot compete against the, against the small donor revolution. We do not have grassroots fundraising networks in place, and therefore we're going to need to bring back in the corporate money." Also, challenges to public financing systems in Arizona and Connecticut we expect to reach the court this year, and we have been very actively involved in litigating those cases. Also, on the policy front, we should see whether or not the Disclose Act is going to move forward in the next couple of weeks. We should see whether or not Congress is prepared to move forward with the Fair Elections Now Act. And both of those are essential to mitigating the damage caused by Citizens United. We cannot let our politics devolve into a backroom swap meet of buying and selling influence. We need to know who is doing what. Equally, we need to be able to allow candidates backed by grassroots politics a fair chance, a chance to mount a viable campaign against those backed by corporate special interests. But finally, it's important for it's going to be imperative, though, and I think we're losing this ground, we're losing this battle largely on the field of the Constitution. And it's going to be critical for progressives to develop, articulate, and advance a constitutional vision that will push against the ones that the corporate interests have so successfully managed to get articulated into law in Citizens United. They have managed to get the court against the mainstream of the American people, against, I think, most mainstream lawyers, to accept that the First Amendment really should have read something like, "Congress shall make no law to abridge the spending of money." Now, the difference between money and speech in First Amendment terms is the difference between robust political discourse and the right to buy an election, and the difference between a democracy where power should where political power follows popular will, and a plutocracy where political power is the property of wealthy interests. Thank you.
Thank you, Monica. I should remind all the folks in the audience that we'll have plenty of time for comments and questions afterward. And unlike the session that preceded this, you don't have to write your questions down. We're going to pass a mic throughout. Mark Schneider, it's funny, labor was very much a part of this case, but you didn't get mentioned in the State of the Union speech, and you don't get mentioned, you haven't been mentioned in a lot of the criticism either, but certainly labor has been affected by this, and why don't you give us a fill on what's different now for you all?
When your membership dips down there below 7%, you stop getting the mentions. All you have had a chance to speak on this several times. I haven't, so you'll allow me to start by venting just for a moment, since I think you probably got it out of your system. And I guess I could pick up where you started, as taking issue with Monica, which is that this is the First Amendment's got to be the most overrated amendment. It has, in my lifetime or my working life, been principally useful to soft-core pornographers and electric companies. In my world, its principal use is to try to hobble labor unions with claims against them. And even I remember this from law school, even the foundational First Amendment cases, Justice Holmes' ringing dissent in Abrams, I think was about what he called a puny pamphlet written in Yiddish, dumped unread on the streets of the Lower East Side by anyone. Now, I too think that should have been protected by the First Amendment, but what was odd about that dissent was it was precisely the uselessness of the piece of paper that led Justice Holmes to say it deserved First Amendment protection. And I think, I should have gone back and read, I think he flipped almost the other way whenever anything was the least bit effective. In the labor area, in my area, labor doesn't really have any First Amendment rights to speak of coming out of the First Amendment. The labor picketing cases stand for the proposition that if speech is at all effective for those on the lower half of the social ladder, it's not really speech, but speech plus, or speech that has an emotive value, and therefore not entitled to First Amendment protection. So I think that I agree with you, we need to rebuild the Constitution, but the First Amendment is a lousy plank upon which to rebuild. It's Justice Kennedy's decision, for all the criticism it received, was built on two rather sturdy First Amendment grounds. And I think the reason that Citizens United decision is so unpalatable is it really vindicates this sort of less than heroic strand of First Amendment thinking. The first thing Justice Kennedy said, which you disagree with, but I think it's sort of indisputable, is that citizens have a right to hear what corporations have to say. Seems pretty unobjectionable. Scalia put it that it would be crazy to muzzle the principal agents of the modern free economy. Those ringing words weren't meant to be ringing to us, but yeah, why shouldn't they have a right to say? But the second one, and the one that I think is the most important doctrine, was called equalization or anti-distortion. It was the holding of Austin. In the marketplace of ideas, we don't promote a diversity of ideas by suppressing one person's speech to promote another person's speech. Joan, when you told me at the beginning here that I could speak twice as long as Mark because he's twice as smart as I am, no one would confuse the ACS, I guess, with the government, but that's paternalistic. I appreciate the offer. But it's paternalistic, and we wouldn't want the government engaging in that kind of micromanaging. But you put these two things together, and the corporations have a whole lot of speech. The holding of Citizens United, as I understand it, from Justice Kennedy's decision, is that favoritism and influence and access, those are his words, are inherent to our democracy, and the First Amendment prohibits the government from limiting anyone's access to the government through favoritism, influence, and access. In other words, I think the precise holding of it is the First Amendment prohibits the states from enacting a rule directed at denying the wealthy a competitive advantage in deciding how society should be governed. And as I said, I think there's a long line of First Amendment cases that will support that as sound First Amendment principle. Now, there's another line of cases I want to point out. But so, going forward, doing what you suggest and trying to rebuild our constitutional structure, I think we ought to look elsewhere. My colleague, John Sullivan, who said he was going to be here and whose appointment to the FEC has been held up such that even if they pass the Disclose Act, there won't be anyone at the FEC to enforce it, has pointed out there's a thing called the Guarantee Clause, Article 4, Section 4 of the Constitution, which says that the Constitution guarantees us effective participation in the Republican form of government. That might be a place to start. And as the speakers we just got through hearing pointed out, after the Civil War, there were a whole cluster of amendments, most notably the 14th Amendment, that seem useful places to start. The problem for the unions is the one you pointed out, and you've done numbers, but SEIU's, my union, it's the biggest guerrilla union in this political world. We're only 2 or 3 of our size. We have the biggest PAC. We have the largest membership. We have the largest treasury. That's why they say we're the ones that stand the most to gain by this. But just to give you a sense of balance here, SEIU's revenues in 2008 were $337 million. That's the pool of money that we fund you guys with, and I forced you guys to allow me to talk. Anyone want to guess? Anyone want to guess? That's $337 million. Anyone want to guess what ExxonMobil's revenues were for that year? $3 billion. No. $33 billion. No. $300 billion. No. Yes. $500 billion. $500 billion. The Bank of America's bonus pool last year was larger than everybody spent on the election last year. Everybody put together. So there's a very serious problem. And the thing, I guess the question I have, I wish the government were here. They didn't even raise this anti-distortion rationale at the Supreme Court. The principle that the rich get to have more influence than the poor was so well embedded in the jurisprudence, or perhaps the Obama administration agreed with it so much, they didn't even try to make the Austin argument to the Supreme Court. Instead, they argued a more modest proposition that wealthy shareholders might have their shareholder rights affected if corporations were allowed to spend freely. And it was on that ground that they tried the case and lost it. So we do have a lot of work to do. And with that, I'll leave it to Mark to describe how we begin doing it.
Thanks. Glad you got that off your chest there.
Yeah.
All right. Mark Elias.
Thank you, and thank you for having me here today. Monica mentioned that there have been a series of these, and Mark has apparently not previously been invited. So welcome. The first public speaking opportunity I was invited to after Citizens United was actually an event at the Heritage Foundation. And I spoke and began by saying there what I'll say here, which is that Citizens United is an odd decision. It is a very odd decision. It is an odd case in every way possible, and its oddity extends to the manner in which it has been embraced by folks who have spent a long time decrying judicial activism. Because, indeed, Citizens United started in 2004, probably the organization started before that, but in 2004 went to the Federal Election Commission and said, we want to make a documentary called The Many Faces of John Kerry. Or perhaps they had made a documentary called The Many Faces of John Kerry, or there was a book that they were turning into a documentary. In any event, I was the general counsel to the Kerry Edwards campaign, and suffice to say, we didn't even file comments before the FEC over whether they could make a documentary called The Many Faces of John Kerry. And the FEC told them no, which honestly is an oddity in and of itself. I mean, this is odd. This is odd on both sides, right? On the one hand, you have this group wanting to make this movie that I don't think many people really wanted to see. On the other hand, you have the Federal Election Commission deciding that it's not entitled to the media exemption. Now, we can fast forward to 2010 when, in fact, Citizens United was told that, in fact, their next documentary is subject to the media exemption. But the strangeness of all of this starts with Citizens United going in 2004 and saying, are documentary films subject to the media exemption? You know, I suppose Michael Moore thinks his are. Citizens United probably thinks theirs is. The FEC said no, right? It isn't. So now we fast forward to 2008, and the story gets stranger because Citizens United decides it's time to make another movie called Hillary the Movie. Now, like The Many Faces of John Kerry, this was not set to be a blockbuster release widely across America. So Citizens United set out a more modest proposal, which was we would pay cable stations to carry it on these video-on-demand services where they basically, the cable services have these huge hard drives, and it's like the YouTube of the cable industry. You pay to put stuff up there, and then if someone downloads it, they watch it, and they pay a modest amount to the cable provider. And they sued the FEC saying, we want to do this. You previously told us we're not able to air our documentaries, and we think we ought to be able to do so. Now, at some point, before this case goes to the Supreme Court twice, the FEC, you might think, would have said, okay, you know what, run your movie, because after all, Hillary the movie was not likely to have an enormous amount of impact. And to make it even stranger, along the way, if you had had a panel like this 3 years ago, we all would have been talking about the fate of the corporate ban that was coming to the FEC. Because in fact, there was a case directly before the FEC involving a real honest-to-God corporation that honest-to-God was going to air an ad, that honest-to-God was going to be dead on in conflict with McCain-Feingold, and that organization was Wisconsin Right to Life. And in Wisconsin Right to Life, Justice Roberts spared the corporate ban and spared the electioneering communications provision, and instead said that as applied to Wisconsin Right to Life, it was unconstitutional. So carved out what I think Monica described as a large loophole. I would actually call a relatively more modest, moderate loophole compared to what we wound up with Citizens United. But the fact is the court decided judicial modesty, presumably, brought it to a place not to address this larger issue. We all knew that Citizens United was in the courts, right? Campaign finance practitioners knew it was in the courts, but it was this kind of quirky case that involved whether or not documentary films posted on pay-per-view sites, on cable systems, were an as-applied exception, another as-applied exception, actually a very not particularly important as-applied exception to the electioneering communications ban of the statute and of the corporate ban more generally. And this case, of course, got briefed and argued before the Supreme Court on that basis, and the Supreme Court decided that it actually wanted it briefed and argued on a more broadly basis, a basis that went beyond that which the parties brought them, and that, of course, was the rehearing and the final decision that became Citizens United. So it is a strange case for, from which I think there are a lot of lessons to draw. I think there are lessons for the FEC, which I think they have started, you may be seeing, which is they ought to pick their battles probably more effectively in some instances than they did in this instance. There are lessons for litigators, for anyone who thinks that the way in which you posit your arguments and the concessions and the arguments you make at oral argument in other places don't matter. I think this was a lesson. And there are lessons for the future. So let me just tap briefly on those. This is a very bad decision. This may be the one thing that Ben Ginsburg and I are going to agree on. This is a very bad decision for parties and for candidates, and it's a really big deal. The first wave of press that came out after this, the election law bar was quoted widely in the newspapers, and they fell into two camps. One camp that said, this is a big deal, this will mean a lot, and it is particularly bad for parties and candidates. And then there were people who said this isn't a big deal. I would venture to say that if you look back at who was quoted on which side, it's not partisan. It's rather practitioner-based. The lawyers who are actually in the game knew that this was a big deal and have seen it's a big deal. Mark Schneider and I were not on the same side of an election recently in Arkansas, and it played itself out. It was a big deal. Okay, there was a lot of ads spent, a lot of money spent in an Arkansas Senate race, and we will see more going forward. And in a world in which the parties and the candidates are appropriately subject to hard money restrictions, this decision will play itself out and make the parties lesser voices in the process, make campaigns lesser voices in the process. It is a particularly big deal down ballot, right? It has its least impact at the presidential level, followed by the Senate, followed by the House. Place where it really, think about it. If you are a corporation that wants to cite something in a municipality, forget about $1 billion. Forget about $1 million. For $100,000, maybe for $25,000, you can own the public discourse around a local election. And so in local elections, this will have an enormous amount of impact. And I think a lot of these conferences don't spend enough time talking about what this means for municipalities and for localities that have had laws on the books that have essentially now been overruled. And it will have a big impact for them. Where do we go from here? I don't pretend to have the jurisprudential credentials or deep thoughts that any of my other panelists do. I will offer one practical solution, which I ended with at the Heritage Foundation, so I will end with here, which is that the Federal Election Commission did something else after McCain-Feingold, which was wrong-headed and which could help make this better by the stroke of the pen of the agency, which is to not treat parties as subject to the same level of coordination restrictions as other outside spenders. There are very good reasons why you want to have coordination rules that prohibit, that ensure independence, and I think in the post-Citizens United world there'll be a lot more time spent on what it means to be independent, and there are good reasons why you would want to make sure that those walls are particularly high for most outside groups. I think that there is less of a reason to have those same heightened rules with respect to political parties, and one of the parts of the Disclose Act that I am always amused is described every time a journalist writes about this. They refer to it as a little known provision, which I'm not quite sure what that means, because in fact it's in the same law as the rest of the provisions. But every time journalists write the same thing, little noticed provision would in fact do exactly that and make the coordination rules more lenient. It would not repeal them altogether, but it would make it easier for parties to interact with their candidates. So I urge all of you to if you run into a federal election commissioner here or otherwise, tell them that they when they rewrite the coordination rules, which they are going to do, they ought to take a more permissive view for party coordination.
Thank you, Mark. Ben, where do you want to go in terms of agreeing or disagreeing there?
With Mark's last suggestion, he's absolutely right. Although, hi, my name's Ben, and I'm a Republican. And I think my task here is probably to provide you with a bit of a different perspective, just because the different perspective can sometimes help inform the overall debate a little bit, or it'll just make me feel better, like Mark, to be able to get a little rant out. I'm really, in my remarks, not going to relitigate Citizens United and the decision, number one, because I don't much like the odds, and number two, because it's very well set out elsewhere. It's called the majority opinion. It's the law of the land. It's what, like it or not, we've all got to deal with. And so what I want to talk about a little bit is what I see as the practical ramifications of Citizens United, both in the 2010 elections and elsewhere. But in talking about Citizens United, I think you can't look at Citizens United in a vacuum if you're going to understand what's going on in campaigns and elections and with the political parties. And in fact, you have to look at Citizens United in combination with McCain-Feingold and what that did and what that meant. When the Republican talks, they turn off the air conditioning to raise the heat level, I suppose.
So that we can hear you.
Yeah.
We want your speech to be heard.
I feel very emboldened, to the tune of several $billion. At any rate, McCain-Feingold, as Mark said, really did have an extreme effect on the political parties. And what the political parties used to be able to do, and this is one of the real misunderstood aspects of it, I think, is they used to raise money in two pots. One was to federal elections under federal law. The other was that state parties, because like there are state candidates out there, could raise money pursuant to the laws of the individual 50 states. Some of the 50 states in their legislative decisions have unlimited corporate money, unlimited union money, unlimited individual money. So the parties had these two pots. McCain-Feingold took away the ability of the political parties to raise money legal under state law to spend on state candidates. That means that the political parties are much weaker and simply can't do as much. And what the political parties have traditionally done for candidates, and this is what will be played out in every race, is the 3 M's. They would provide money, they would message for the candidates, and they would provide mobilization to get voters registered and out to vote. In taking away that ability of the parties in McCain-Feingold, combined with the decision in Citizens United, which I would call sort of a ringing endorsement of free speech in the country, but we'll, I'm sure, chat about that later. But the end result is that candidates and parties are limited in the amounts of money they can raise for money and messaging and mobilization, while special interest groups of the right and the left are unlimited in what they can do, not in direct contributions to candidates, but certainly in the messaging and mobilization part. And so whatever you think of campaign finance reform and what it should be, it seems what it should not be is a smaller voice, a smaller megaphone for the candidates and political parties to support their candidates have in comparison with special interest groups, be they corporations or unions or trade associations or rich individuals. So at this point in time in the 2010 elections and going forward, you've got this really odd situation out there where the candidates and parties are sort of bumbling along, raising money in limited chunks, and special interest groups can now use their treasuries to promote free speech in unlimited amounts. That's an imbalance that does not have a particularly positive effect, I think, on the public debate. So the battle in the upcoming elections is really the money, the messaging, and the mobilization, and who's going to fill the voids that have been left by the combination of McCain-Feingold and Citizens United. I understand that Citizens United is very much the flashpoint today because of the notion that corporations will now have unlimited resources to spend. That has not historically been the point. I take it that the Chamber of Commerce raised and spent $144 million, or at least claimed it last year. That yielded a Democratic president and larger margins for Democrats in the House and the Senate. So at the end of the day, money is not everything. Ideas do matter. So far, at least, the reality is that the left has a better model for dealing with the post-McCain-Feingold Citizens United world than the right. Republicans, for better or for worse, relied much more on a centralized political party system to do the money, the mobilization, and the messaging than the Democrats and the left, thanks largely to the influence of the unions who have had terrific programs in terms of mobilization and messaging. The Democratic Party committees were never as strong as the Republican Party committees. And so the reality is that between the Democracy Alliance and wealthy individuals who support the left and what the unions and your 501c4s do, it is a much better organized, much better funded, collected effort than the right has right now. That's going to change over time. I mean, we'll figure it out eventually and at least gain parity or use that unbridled corporate strength that seems to be lurking out there. But the essential point is that the current system is going to make it a lot easier for special interest groups to dominate the blocking and tackling of politics and funding candidates than the right has for the moment. But the point still is that you've got a very distorted system now that does need some correction. We would probably disagree on what that point of correction should be. But it is a kind of bizarre system that we have now. So with that, I think we should probably open it up for questions, John.
Yeah, I've got. I'm glad they turned off the blower because now we can hear each other, and frankly, we probably have exactly 40 minutes before the AC really runs out. So we'll fit in just nicely. I want to ask the panelists though about two things that bring us more up to date. One will be on the court's recent order in the Arizona case. But before I ask about that, just Monica referred to the Disclose Act, which is proposed by Senator Chuck Schumer and Congressman Chris Van Hollen, that's been in the news because of the proposed exemption for the NRA. And I just want to get a little feel from the panelists about whether, first of all, whether the act would make much of a difference in terms of what we're talking about here, and whether it has any chance to become reality before the midterm elections. Monica, you want to start since you had referred to it?
I mean, I think that it would make somewhat of a difference. It would certainly help to close off some of the means in which corporations are able to mask their political spending. I think will be very important, just from a sheer perspective of accountability.
Yeah, I agree. I think what the congressman said upstairs is something that we agree with, which is it's going to be a lot harder for corporations effectively to advertise if they have to identify themselves, and that's the point of the Disclose Act. it's had a tortured history. I would have thought that the Democratic Party, given all the polling, they would have leapt over that legislation, but instead they're sort of tripping over it right now. So I don't know how in the end it'll come out. I know it's also interesting. I don't really understand why that the progressive community is not at all unified on this. I mean, the three of us maybe, but some of the unions have had a different view, and many of the C4s have had a different view about the Disclose Act.
What I know about how a bill becomes a law, I saw on Schoolhouse Rock on Saturday morning. So I won't predict how it will move, or
Or not move. Yeah.
or all of that. I will say that I am amazed. I am pretty sure. I don't have a video library to go look at this, but I am pretty sure that during the pendency of McCain-Feingold, the position of Senator McConnell and others was, let's just disclose everything. Let's have it, like it was, and it wasn't just disclose, it was like instant disclose. Like it would, there'd be like people running around with wireless internet access, posting stuff on the internet instantaneously. I mean, it was like Uber disclosure. And Ben may be able to explain why and Virginia was always held up as the model, like take everything and disclose it. And Virginia's got does have a fair amount of a fairly robust disclosure regime. So I guess for my 2 cents, it is just a further question to Ben, what is the reluctance to disclose?
Well, I appreciate you're trying to focus the bill on disclosure. Frankly, the disclosure provisions are not what my objections to the bill are. I think there are particularly onerous disclosure requirements put on corporations from which unions would be exempted, so you've got a huge paperwork burden. I think that the notion of listing the 5 biggest donors on the ad, basically you can't run the ad. If you want to disclose the 5 biggest donors on a website so everyone can look at it, I don't have a particular problem with that. I think it is a very cynical bill. And to give you the view from the right, I know you guys are calling it the Disclose Act. We refer to it as the Schumer-Van Hollen Act because you've got the 2 most political Democrats possible to put forward a bill that in fact does try and tilt the playing field. For example, the bill forbids government contractors from participating in the First Amendment rights they were just granted by the Supreme Court on the grounds that if they're government contractors, they shouldn't be using government money to engage in this political speech. Okay, what about the unions of those government contractors? Why are they allowed to participate when the government contractors aren't? Foreign corporations are prohibited from giving, but not the unions of the foreign corporations, or international unions that may meet the same threshold requirements. So from a Republican point of view, it is a pretty tilted bill. I would just say that the carve-out for the National Rifle Association is perhaps the fitting symbolism for the bill to get it passed. There is a cutout from all those disclosure requirements for the largest of the large groups. And so at some point, when you start having to exempt the largest of the special interest groups from the provisions of this bill, the sort of essential cynicism of it seems to come out, because after all, this was put forward as a bill designed to help the little guy in politics and not the big guy, and now there are exemptions for the biggest guys. So if it at the moment appears to be in some trouble, I suspect that's why.
I disagree. You'd be surprised. I wouldn't want to impose on any of you to actually read the Disclose Act. It's like that, and it keeps changing day to day. But there is, in fact, no exemptions for unions in the Disclose Act, and the National Rifle Association doesn't, whatever else you want to say about it, doesn't get its money from corporations. The point of the Disclose Act is to have corporations and unions identify themselves when they inject money into politics, and it does that in its current form.
One last thing I want to touch on is that, Citizens United didn't come out of the blue from this Roberts Court. It's obviously been part of a series of decisions that we've seen in the last couple of years ever since Justice O'Connor retired and Justice Alito came on that gave the court a 5-justice majority to read the First Amendment in a different way for these campaign finance regulations. And I was wondering what the panel made of the court's order about a week and a half ago in the Arizona case relative to its public financing law. Very brief order, I think just 2 sentences that blocked that from being in effect for the upcoming elections. It involves the matching funds for candidates who are running against opponents who aren't part of the aren't taking the public funding and spend a certain amount of money, and once they spend up to beyond this cap, matching funds kick in. And I presume that, well, I know Governor Jan Brewer was certainly counting on those, as were other candidates in the state. And I just wanted to, maybe starting with Ben, if you think that this could end up being more consequential down the road, or just what you make of it. And obviously the court hasn't said whether it will grant cert, but the signal certainly is there to get more involved in this kind of regulation too.
Well, I think the signal is there more for efforts to publicly fund campaigns than it is for sort of the broader rights of corporations to speak. So I think it sort of falls under the Randall versus Sorrells line of cases that knocked out Vermont's very low contribution limits as too low, and I think it falls more in that than the Citizens United broader free speech. But it's certainly a consistent ruling with where the Roberts Court has been.
Go ahead, Monica.
I just wanted to make clarification. We're litigating the Arizona case, and so, the matching funds at issue in the Arizona case are probably better called trigger funds. They're not the sort of matching funds that you think of when you think of, for example, the presidential primary public financing system or the Fair Elections Bill that's now been introduced in Congress. This is something in which as Joan explained, if the race becomes particularly competitive, a public finance, an additional grant of funds to the publicly financed candidate will be triggered if a privately financed opponent spends above a certain level. And I think that the court's willingness to intervene in this case is really shocking. The primary at the time the court intervened last week was less than 2 months away. I mean, it is like changing the rules, saying all of a sudden, field goals are going to count, 7 points in the third quarter of a football game. That's my sports concession. I mean, it's just the basic unfairness of the decision is shocking, and it means that basically publicly financed candidates in Arizona, who are the majority of Arizona's candidates, suddenly find themselves hobbled in the middle of an upcoming election. And the theory of injury that the court was rushing into seemingly to defend here is at best abstract. I mean, they feel like a privately financed candidate or an independent expenditure organization might be discouraged from spending if they knew that their opponent was going to be able to respond. But this system has been going for 12 years, and there has been no indication that independent expenditures or privately financed candidates have been discouraged. They've raised as much money as they could, and they've spent as much money as they could. So for the court to do this, I think, is really a shocking signal of how far, and how activist they're willing to be.
Yeah, I think a dog after it bites someone often will get complacent. It's made its point. And one question we had after Citizens United was the Supreme Court had made its point and was going to just sit for a while. It was a controversial decision. Well, the answer is no. They're sincere, and they think that the Constitution requires them to act in these cases.
I misspoke before. It's not Randall's versus Sorrells. It's the millionaires
Yes,
loophole
Davis,
that
right.
they threw out.
That's okay,
Davis
then we-
case. So I apologize for that.
But what's interesting about it, though, is even though it comes up through another line, it does raise the question of who the they is. You know, for all the prior ones that followed, that preceded Citizens United, it was a 5-4 group, but for this order, as all of you know, we had no recorded dissent. And it's just, you know, a brief order, no dissent, and it makes you wonder how much all 9 were aware of what was going to go on in Arizona, and, you know, where some of those dissenters from Citizens United might have been in this. But, you know, again, it certainly changes things in Arizona, but how far it might change things nationally will depend on if they take cert and what happens then. Did you have something else, Mark, you wanted to add?
I actually had more of a question than a statement about it. But I was going to say this sort of strikes me as it's under the Davis line.
Yeah.
And what I don't recall what the final tally was in Davis of the remaining justices, of the justices currently on the
It
court.
was the same.
That was a 5-4, but of
It was
course,
the
we
5-4.
still had, it was David Souter, not Sonia Sotomayor.
Right, so it doesn't.
Yeah, you know, would be the same thing. In fact, all of the more recent ones have been, in this line, have been the 5-4. So, thank you, panelists. Now we'll open it up to you all for questions on, you know, okay, just wait for them. Do we have somebody with a mic? There's a fellow right there. Thank you. It's on.
Hi. Can you hear? Yeah. I am a maximum federal donor, which means I give the most amount of money I possibly can under federal law. I give it all to Democrats. I also give money to corporations like Planned Parenthood and the American Civil Liberties Union and the Human Rights Campaign and the NAACP and other corporations. I happen to think that the Citizens United law is a great law. It is a law that allows those corporations to get involved in the body politic, present issue-oriented advertisements, and lets the public know what's going on. I can't imagine a law like McCain-Feingold being consistent with First Amendment principles of free discourse. I think what Mr. Republican Ben says there is very well stated, and what Mr. Democrat Mark said is a little scary.
The old regime that was well, it's still in place, but it may be superseded to some extent by Citizens United, were that corporations and organizations and unions could create PACs. And the key feature of PACs is that there was voluntary money, so that if you wanted to give money to people of a like mind who you know, supported civil liberties or supported a choice in abortion, you could give a contribution to their PAC, and then they could participate in the political system. The difference with Citizens United, the principal change, is that now corporations and unions are allowed to use funds that weren't voluntarily collected for political reasons, but were just collected for other reasons. It's a very different regime, but I don't think the old regime prohibited people who wanted to contribute to join groups and engage in politics from joining groups and engaging in politics with their money.
As the scary one, let me try to address what the thrust of my comments go to the question of whether or not courts ought to arbiter the disputes that are before them, or whether they ought to reach out for disputes that are not. Now that, as I said, is actually something that is oftentimes heard, not at necessarily only gatherings like this, but gatherings of conservatives. The idea is that if litigants come to a court and say, we want to run a documentary, and we think that running a documentary should be permitted under these circumstances, and there ought to be a carve-out from the laws banning corporate expenditures, then the courts ought to decide that question. And I thought that my principal objection, though I may not agree with you on the substance of Citizens United, my principal objection is that this case was a case about that over time morphed into a case about something else. The fact is there was another case involving Wisconsin Right to Life that was an ideological corporation that wanted to run ideological ad. And in fact, the U.S. Supreme Court told them they could do so. And it struck me that if the court thought that that was an appropriate as-applied challenge and not a place to revisit the entirety of the corporate ban as applied to non-ideological corporations, as applied to express advocacy rather than issue advocacy, if that was not the opportunity to do so, it struck me that Citizens United was a particularly odd, to use the word I keep using, opportunity to do so. So I hope that's not terribly scary.
Thank you.
Alan Morris. I was on the losing side of Citizens United, and that's not what I want to talk about. I want to make an observation about the Disclose Act, but it ties back to McCain-Feingold, and then ask the panel a short question. The concern I have about the Disclose Act, and I did what Mark told me not to do, which is I actually read it. It's really scary because it is so complicated for such a simple proposition. And the problem is that the people who are writing it are worried that some dollar, someplace that went through some three-level conduit is not going to be disclosed, when they ought to be worrying about the big question, which is major corporations giving large amounts of money and how they're going to get the basic thing disclosed. So I plead with everybody who has any sense to try to do this. And we saw the consequences in McCain-Feingold because the Wellstone Amendment, Paul Wellstone wrote a provision in there that made it apply to nonprofit organizations in a way that hadn't applied before. That triggered the NRA, the Wisconsin Right to Life. The for-profit corporations didn't care about it. They weren't the ones who were behind Citizens United. This was an ideological matter. So please, don't go so far. The second question is, Citizens United deals with independent expenditures. I want the panel to ask opinion. When is the Supreme Court going to get to the issue of corporate contributions of actual funding to candidates and parties? And do you think that will be upheld, the absolute prohibition, or whether it will be subject to the same rules that other persons, which they now have equated with individuals, is going to be?
What do we have percolating up? You want to start, Ben?
Sure. My guess is that the court will never get to corporate contributions to individuals. Seems to me that that is something that, at least in Citizens United, they paid lip service to as a long-standing tradition that they think is sound. I think corporate union trade association contributions to political parties is probably the correct solution to deal with the imbalance that I talked about before with special interest groups having so much more money in the process than candidates and parties. And if you're worried about the corrupting effect of corporate contributions or union contributions going to candidates, fair enough. The answer is, why shouldn't the political parties be able to use the very same money for mobilization and messaging activities that special interest groups are now able to use? And so I think the RNC case that Monica mentioned is likely to be that vehicle. I'm not sure that case is exactly positioned correctly, because I think the corruption or appearance of corruption issues on candidates is still a little bit too relevant there. But either that case or something along the lines of what Mark disclosed, a case or talked about, a case where the coordination between parties and candidates is given a freer rein, could also include a lifting on the ban on corporate contributions.
I don't see what you're suggesting happening quickly, but it does seem to me that where we're headed is a regime that with First Amendment continence is disclosure and disclaimer, but it's unclear to me over time whether it will countenance the kinds of restrictions that now apply to candidate contributions.
Did you want to add anything, Monica?
Yeah, I just wanted to address the complexity issue. I mean, obviously, we would all like the laws to be as simple as possible, but you do have to work. When corporations engage in trying to influence the outcome of an election, they generally do so using a nonprofit as a conduit. They create a front organization, and you do have to account for those if you're not going to have a meaningless law. There was an example in California, Intuit Corporation, not someone you would think of typically as a corporate bad actor, put, I think, $100 million into a front organization to influence the outcome of the election for California state comptroller. And the reason for this is because the existing state comptroller had proposed that California's residents should be able to file their taxes for free online, and created a free software system to do this. This would have cut into Intuit's sales of TurboTax. So they funded a $100 million attack ad blitz using a front corporation to try to take the guy out. I mean, we have to account for this kind of behavior, otherwise the law is not worth passing.
Yes, right here in the blue shirt.
I want to pick up on a point which I think Ben Ginsberg was getting at earlier, which is that if voters are rational and well-informed, you wouldn't think that money should be so influential. You can air all the commercials that you want, but if I prefer candidate A's policies to candidate B's, I'm still voting for candidate A, regardless of how much money they're spending. So for money to be so influential, and it sounded, I think, like there might actually be some debate on the panel about how influential it is, but if it's so influential, there has to be some sort of a political process failure, that we, the voters, are doing something wrong. So I'm curious what the panel's thoughts are on what the vulnerability here is, what's going wrong in the political process that allows corporate spending to be so influential on how people vote, and what that tells us about how we should be regulating political money, or what the ramifications of Citizens United is going to be.
Let me just say briefly, and this is just my own, I don't have any empirical evidence, so I'm unburdened by facts, or at least provable facts. It is the reason why my supposition is that this is going to have the greatest impact the further down ballot you go. Because the fact is, if I asked you why you voted for who you voted for president, you'd give me a long list. If I asked you about Senate, it would be a somewhat shorter list. If I asked you Congress, it would be a little bit shorter list. If I then started going through county executive, school board members, city, right? The level of information that the voter has becomes less. So, and one of the things that I think post Citizens United, which goes a little bit to the last question about future litigation, at conferences like this, we always wind up talking about at the top, right? What does this mean at the top? I think a lot of the litigation we're going to see, candidly, may also stem from stuff that comes out of states or comes out of municipalities. But I think the answer to your question is that this is going to have, for $50,000, you can educate someone. Forget about smear ads and all of that. You can genuinely educate people about one candidate, and in the course of doing so at a local level, you can mobilize voters, you can put out message, you can really influence that race in a much more direct way than you can at the presidential level, where you're right, there's a lot more information at stake.
Garrett, and then we'll go to this side of the room. Go ahead.
I just want to ask people who work in this area whether maybe the real effect of this is going to be. There's been some discussion. I know Ben talked about how, look, the Democrats won, even though there were money being spent X or Y. But isn't the real influence of this to pump more money into the system, which is going to mean that the people who go into politics more and more are people who are willing to spend their entire lives and their careers on the phone begging for money? And the more that becomes the kind of person who is our representatives in Congress or in legislatures or anywhere else, the effect on politics, even though you can call them Democrats, Republicans, independents, single taxers, it isn't going to make any difference, because I would like everyone in this room to ask themselves whether they would like to run for the United States Senate if the chance came up under the current system, knowing that they would spend, with luck, the next 6 years of their lives begging rich people for money and having that be the content of their careers. And Justice Stevens said in his dissent, he really zinged, it seems to me, the other side by saying there are a lot of things wrong with American politics. No one but the 5 justices on the other side thinks it's not enough corporate money. Could you talk a little bit about the effects we can't see, not just the gross results of who wins X election?
Well, I think that's right, and I think that there are 2 types of politicking that we want to distinguish here. Like, I wouldn't run for Congress, but I wouldn't have run for student council president either. I'm not the sort of person who likes to go around shaking hands and meeting people necessarily, not that I'm antisocial. But, you really see this difference when you see publicly financed campaigns, because publicly financed campaigns do require you to do an amount of grassroots activism. You do have to still attend the barbecues. You do have to still, go around, go door knocking, meet your constituents, canvass, and I think all of that is good and positive, though not something I personally would be inclined to do. But what you don't have is the sort of dialing for dollars mentality that more and more is dominating our politics, where the only people whose phone calls you take are the people who represent wealthy interests or are themselves personally wealthy. And I think that does very much affect the quality of our politics at the candidate level and also at the level of discourse.
Well, I think your point is well taken in the sense that you don't want your candidates for office, and especially not your elected office holders, having to spend all their time dialing for dollars. You want them talking about issues. You want them doing grassroots things. You want them out doing the nation's business if they're legislators. I think the problem is you've got a system where the candidates and the parties can't keep up with what the special interest groups are doing. And so you've now got this system that you've had in place with severe limits on candidates and parties, and that's where I think the real problem is. Now, if you want a sort of a cosmic solution to that, public financing, I think, is a very difficult bill to sell. Food stamps for politicians is just not going to be kind of a winning issue in the current environment. But there is a way to get more money to political parties and essentially let them be the funding sources for candidates, once again, to keep up with the special interest groups. And potentially one of the ways to do that is to lift the corporate ban and union ban on what can be given to the political parties. Let the parties fund the candidates, let them do the messaging, let them do the mobilization. Someone mentioned the Virginia elections before. The truth of the matter is special interests play less of a role in Virginia than probably any other competitive state in the country, precisely because you don't have limits on the amount of money that can be given to candidates and parties. So special interest groups don't play as big a direct role. If you want to stop candidates from taking money directly from those sources, fine. But I think you do have to set up the parties as the funding source then.
I mean, we've seen what using the parties as a funding source looks like. I mean, we saw that in the late 90s. It led to an escalating series of scandals culminating in Enron. I don't know that you can say that that keeps candidates from being beholden to special interests. I think it makes them more beholden.
Let's have a
I'm
question
not
on this side of the
sure
room.
Enron was caused by political giving.
I'm going to bring the mic over. I think this gentleman has had his hand up for a while, and then that woman back there. Thank you.
Hi. I was not troubled with the outcome of the decision for the case that was presented. And I think in our discussions it's important, and in any corrective legislation, I think it's important to distinguish between nonprofit organizations and for-profit organizations. I am very disturbed by the decision and its impact on for-profit organizations, as I think most people here are. But the decision has been, said by many people as allowing people to express their free speech rights and so forth through corporations. To me, I find it just the opposite, because it causes individual shareholders to indirectly have to support candidates for which they may with which they may not agree, and to me that is just the antithesis of the free speech that the court in its decision thought it was supporting. My question is, can we not, and maybe there is something in the works that would limit the, rather than the Disclose Act goes, you know, somewhere there, but something to limit the ability of corporations for-profit corporations to contribute to political campaigns or the political process without the authorization of the shareholders. I mean, the way it looks now, it can be done by corporate officers, maybe with or without the approval of even the board of directors. I'd like to see something where at least the shareholders have to authorize it. That might not protect the minority shareholders, but it would go somewhere.
Anybody want to address the shareholder interest? And you know, originally there was some talk when the case was being heard of just maybe there would be that corporations wouldn't take this kind of decision and run with it because of shareholder pressure, but that sort of evaporated. Anybody want to pick up on?
My union has proposed a rule starting with the low-hanging fruit. About half of the shares held in the country are held indirectly. In other words, you're by a pension plan, by my Index 500 fund held in my 401k, which is the government's preferred method for me to retire. And I guess you could say about if I held stock in General Motors, I could always sell it if I didn't like what they had, what they were doing. But I can't really say that about the extent to which I own General Motors through my state pension. And so we thought, at least as to those shares, which are half the shares, the corporations ought to offer a rebate for the pro rata share of every penny they spend on electoral politics, where people don't have any say. That would seem to be a start. I'm not, you know, that's what we proposed.
There is a bill on the floor that does exactly what you're talking about. It was introduced by Representative Capuano, I believe, and has the support of Barney Frank and some other financial services people. It's called the Shareholder Protection Act, and you know that may move as part of this package of reforms that's currently being contemplated.
I'm about to lose my run for Mr. Congeniality of the panel, but I suspect that will happen about the same time that the unions agreed that individual union members should be able to sign off on contributions to candidates, and union members have to sign off on the political mobilization activities of the unions.
We actually, first of all, union members, this goes to an old fight, but people that are represented for unions for collective bargaining already have a right to get their money back if they don't like the politics of their union. And as far as unions being willing to agree to have their board or their executive council approve their political agenda, we for instance, supported the Capuano bill, which does just that. So we're fine with it. This is really a distraction, the union thing. The unions stand greatly to lose by the current regime and would like it changed.
Not all unions do that, and I believe there aren't votes on individual expenditures, which is what's being suggested here.
We got a question back there, then.
I chair the San Francisco Ethics Commission, which includes a voter-approved campaign finance program. So I'm very troubled about restrictions, especially the Arizona decision, that would control these experiments at the state and local level, which could be very promising examples for us to think about. I want to engage Mr. Congeniality on some specific points that nobody has picked up, and then I have a question for the panel. You mentioned some of the things about the Disclose Act that you don't like, that are fairly technical, and I am burdened, like many progressives, with a desire to be intellectually consistent. It slows us down and makes us really rotten at messaging, but there you have it. It's our curse. You talked about government contractors and that you don't think that You can draw the line that people who receive government contract money should be able to simply separate the source of their funds so that they can contribute some to electioneering. But we don't seem to be able to allow Planned Parenthood to make that distinction when they get federal funds and want to do other activities with private money. If we can do it, we can do it, and if we can't make those segregations of funds, then we can't do it, but you can't argue it both ways. And the other is that I think if we can figure out how drug companies can put their prescription warnings on television ads, we can figure out how to solve your problem about 5 co-supporters being identified on a campaign ad. I think there are ways to resolve that in the interest of information. My question comes out of a conversation I had just after Citizens United came out, which was with the president of a very heavily regulated industry in a highly competitive national universe. And his reaction to Citizens United was not, hooray, I can buy elections. It was, damn it, we are going to be pressed to spend a lot of money. The nuclear arms race will force money into things that will not add to greater truth, and I wish it hadn't happened. I don't know if on reflection he still feels the same way, but I wonder if there's some way that we can think of business as not a unitary all-in support, but be more subtle about joining forces with people who don't want to see just tons of cash poured into it to no avail, but just more of that din that we hear at the end of elections.
If I can just very briefly address your second point, not your question, because I think
Since you are Mr. Congeniality.
because I think it's actually an important point, and then I promise. The top 5 donors is actually already in the law in Washington State, so it is not this unworkable thing. The fact is, Washington State, as you correctly point out, I always tell people there are two kind of legal regimes. There are the minis, like, federal government passes a law and then states adopt a miniature version of it. And then there's the laboratory of democracy approach. And campaign finance is very much in a mode of the reverse, where there's a lot of stuff going on a local level that is percolating up. And this top 5 donor disclaimer thing is a good example. It's something that I assume the sponsor of the legislation saw was being done in Washington State. So I apologize for interjecting, but I just wanted to make that point.
I'm sure many of the problems could be solved with negotiation. I think the problem with the Disclose Act is, again, the twofold perspective. Number one, it is by Schumer and Van Hollen. This is not one of the great reformers, of which there are many principled reformers amongst the Democrats in Congress on campaign finance. That's not where the Democrats chose to go with this bill, and instead took perhaps their 2 most effective politicians. And so I think that has caused a great deal of the sort of bifurcation you've seen. No, go ahead.
There is a move afoot by large corporations, many of which have signed a pledge they're not going to spend money. And I think you're quite right that there's people are not all of corporations are certainly not all of one view, and some of them worry about this kind of, well, if Boeing does it, GD has to do it, kind of thing. And I think you raise the ultimate question, which none of us really can know, which is a cultural question, which is over time. Ben made the point that half the states have a regime that was like Citizens United, and there's some bad examples, but it's not massively more corporate money spent in those states than other states. Over time, what are we going to see in terms of the culture? Is this going to be a green light with Justice Scalia saying this is like almost a corporate duty and everyone's going to go along, or in fact is there going to be resistance and we're not going to see that much change? And I'd be interesting to be on the panel this time next year, and we'll see what we've learned.
If I can just address, because there are a couple of things that I hear at these conferences. One is that the bill was negotiated behind closed doors, which I never quite know what that means. I don't know if they were supposed to rent a tent and do it on the lawn someplace. But the other one is this, but we don't, but this senator is involved and this congressman is involved. I mean, Congressman Van Hollen actually was a principal sponsor of the last major reform act in Congress, which was the Honest Leadership and Open Government Act. So I disagree there. Number two, the bill in the House is actually co-sponsored by Congressman Castle, who is actually a Republican candidate for U.S. Senate right now. So the bill in the House, which is where the bill is moving first, is actually bipartisan, and one of the two of the bipartisan is very much a Republican, very much running for higher office. So I'm not quite sure I know what to do with that. With respect to Senator Schumer is a past chair of a National Party committee, as is Senator McConnell, who, when the objections to the fact that of Senator Schumer's involvement, no one on the Republican side seems to say, well, Senator McConnell shouldn't play any role in these discussions. And after all, he has been at the forefront of virtually every campaign finance negotiation or bill that the Republicans have suggested in the last 10 years. Finally, Senator Schumer is the chair of the Rules Committee, which is the committee of jurisdiction. So you would assume that Senator Schumer would play a role. So it seems to me that if Republicans no longer believe that there ought to be disclosure, then they ought to just say, we didn't mean it then, or we kind of meant it then, but we don't mean it now, or whatever it is. But this idea that somehow the shape of the room wasn't right, and we don't like this congressman involved and that congressman doesn't count, I think is not really a valid objection to the Disclose Act.
Look, the difference is that Senator McConnell has admitted he's there for partisan purposes, and Senator Schumer and Van Hollen are there trying to say that they're there for altruistic purposes, which doesn't quite work. But let me address.
I don't remember Senator McConnell saying he was there for partisan purposes.
Well, I don't think. I think he was.
Okay.
That's
where we're going to end.
Could I address the large corporation issue for a second?
Just
which
real
I sort
briefly,
of dodged.
because we're very briefly. Go ahead.
Number one, this is what corporations, if you're out selling a product to the general public, are not going to start engaging in the sort of red meat politics that is suggested by independent expenditure ads. So I think I think the fear is overblown, but nobody believes that kind of.
Thank you so much for the great questions, and thank you especially to the panelists, Ben, Mark, Monica, and one last reminder, please join us for the luncheon featuring Mayor Cory Booker immediately following this session in the ballroom. Thank you all so much.